Number one is called the contract assignment. So we have party A, party B, party C. A is the owner, B is you, and C would be another investor. So the idea here is you put a property under contract with the owner, between A and B, a purchase agreement where A agrees to sell and B agrees to buy. That contract will have no prohibition against assignment. Now, typically a standard real estate broker contract will have an anti-assignment provision. If you write and or assigns, that doesn't make it assignable. What you have to do is actually strike out anything to the contrary, because if it says it's not assignable, putting and or assigns doesn't make it so. If it doesn't say it's not assignable, then it is assignable whether or not you put and or assigns. I put and or assigns anyway just because I want the seller to know I plan to assign it, not necessarily purchase it myself. So as long as there's no prohibition of assigning it, you're assigning your purchase position to C, who's going to step in your place as you and close directly with A. And you get paid, anywhere depending on the size of the deal and how good it is, $3, $4, $5, maybe $10,000 on a commercial deal, maybe even more. What you're doing is you're selling your contract position with A to C, another investor. Now C has to abide by the terms of the contract with A. So if it's a cash deal, then C pays cash. If it's a terms deal, then C gets the terms deal. Whatever you negotiate with A, you're assigning it so C can step in your place. And you get paid. Now there's a couple of ways to get paid. You can get paid at assignment. You can get paid at closing when C closes with A, or you can get some at assignment and some at closing. And the third scenario is the typical scenario. You get some money at the assignment, non-refundable, and then when C closes with A, you get the rest. And the reason you want to get some at assignment is, what if C doesn't close? You want to make sure you get paid. Okay? So let's say your fee is $5,000 for the assignment. And let's say you gave the owner $1,000 in earnest money. How much should you get from C at assignment? Well, I would get at least $2,500, at least half, and then the other $2,500 at closing. And that way, if it doesn't close, well, you lose your $1,000 that you put up to A, but you still get $2,500 from C, and you still net $1,500 for your effort. And that's a basic contract assignment. Again, remember, this doesn't have to be a cash deal between A and B that can be assigned. It can be a terms deal, a lease option deal, a straight option, a lease. It could be any variation of contract or agreement between A and B that expressly allows you to assign it, or at least doesn't say that you can't assign it. Now, let me clarify there. A cash deal can be assigned because there's no harm to A. It's cash is cash. But if it's a terms deal between A and B where A relied on B's credit and you assign it to C and C's credit has not been checked by A, is that fair to A? Maybe not. So in that case, you want to get A's express permission for the assignment in the original contract. Okay? Also, when you do the assignment agreement between B and C, make sure there's plenty of disclosures and disclaimers about the property being as is, because I've seen C's sue B's for not disclosing things about the property that they knew or should have known. I have a very good form in my forms package there that covers this scenario. Okay, so that is the first no money down technique. It's some money down, maybe $1,000 earnest money to A. If you're lucky, you get away with $100 or $500, but really that's all the money you're putting down, and then you're walking out with $5 grand on the deal.